To all the participants who are present here and prospective Ramyanan, I welcome you all to the second day of this monthly workshop on journey of the corporate entity to its lifetime, where we will all be studying company law. Ramyanan, I really hope you are doing well today, and I really hope that this session is very insightful for all of you who are present here. And I thank all the participants for understanding and for the cooperation throughout the session. Thank you so much, Chandana, for joining us. So we can now begin the cycle.
Thank you. Yeah, so sorry for the inconvenience for the last 2 days. Hope you still remember what we learned in the last session because we will pick up from where we left off. Am I audible?
Yes, ma'am.
Okay. So, we had left the previous session at the stage of incorporation. We first looked at the fundamental concepts, what constitutes, what are the special aspects of company form of business than any other. And then we looked at how the incorporation procedure takes place. We understood how to read the Companies Act. We always read it along with the rules and we read it along with the schedules also, and we explored some fundamental concepts and familiarized ourselves with what constitutional documents are. So it would be correct to assume as of this session that um, in the lifetime of the company, because we're doing journey through the lifetime of a company, so whichever company we are hypothetically taking, that company is because we have completed the incorporation stage. So I am not presenting the PPT because I would like it to be more of a dialogue. Otherwise, it's turning into sort of a seminar. So, for today, we will be doing the once a company is incorporated, what happens next? So, basically, I had left the previous session with a question, if you all remember, that we had not explored one very important, one very key fundamental concept, that was separation of ownership and management of a company. Generally, when you create something, you tend to take the responsibility and accountability of something because it's yours, you sourced it. But in a case of a company, the owners of the company are different from the managers of the company. And I had asked you to just think once, how do you think that works? Like, how does that function? So, do any of you have any preliminary thoughts on this? Or you can take 2 minutes and you can write your responses in a chat box in brief on how you think this concept of separation of ownership and management can function in reality. So, okay, let's put it this way. Who are the owners, or who are the owners of the company? Who is the owner? Tell me. Shareholders and promoters.
Directors.
Directors. Director owners. Promoter may be correct. So these shareholders and promoters together, they would come under what category? You will know this because we looked at an MOA. What terminology does the MOA use? Members. That means Because the shareholding of the company can be very diverse, especially as the company is growing. Who are the shareholders of the company can just keep changing on a very weekly basis. So the members of the company as on a particular date will be considered to be the owners of the company as on that date. Okay. And who are the managers? Directors, correct. So when we say that there is separation of ownership and management as a fundamental concept, that means that whoever owns the company, that is all the members who own the company, don't really involve themselves in the day-to-day functioning or the daily affairs of the company. And that is done by managers, who in turn are people who don't have a stake or who don't have an interest, so to say, in the company from an ownership standpoint. Like at no point can the two merge. This we understand. Now you think and tell me, how does this link, this concept of separation of ownership and management, how does this link to the limited liability concept that we explored last class?
In limited liability concept, the promoter, the shareholders have not the responsibility if their company is in loss.
Then whose responsibility is it if the company is in loss? Correct. Liability to the extent of shareholding. Can you explain this a little more? So let us think of it this way. Um, Suppose I am a shareholder and my name is in one of the I am also a member. I'm one of the members of the company. Okay. So if I have say 100 shares, and for those 100 shares I have paid 90,000 rupees, and 10,000 rupees is still unpaid that I need to pay for those shares. It's unpaid. Now, tomorrow, if the company is going to shut down or the company is in losses and it's trying to recover, to what extent is my liability? 10,000. Limited liability, what we understood last time, limited liability means that if I am the person who has the grocery store down the lane, if something goes wrong, the recovery agents can come to my house and take my jewelry, take my sofa, take my furniture. But if I am a company, I've opened a company and my company is loss making, then the recovery matters pertaining to the company cannot come to my house. That is what we understood by limited liability. But the second part of this concept also means that every shareholder who has paid some money to get certain shares, if there is an unpaid amount remaining for his share subscription, if he owns 1,000 shares worth uh, 1 lakh rupees, but he has not paid 10,000, he has only paid 90,000 rupees, then to the extent of unpaid amount on those shares, he is still liable. So his liability is still limited to the extent of how much shares he owns and how much value that shares has. That was just a 1,000 shares, 1 lakh rupees. But he has paid only 90,000. So for that 10,000, he is still liable. He has to still be liable to that limited extent. So limited liability means that there is a number that you can put on the extent of liability a member has. But if there is some unpaid amount in that what he has subscribed to, that is still his own liability only. So when we say separation of ownership and management, whatever management the board of directors are doing, they are not doing with their own financial stake in mind. They are managing the company. So when there is something that goes wrong in how they managed it, then you can say he's an officer who committed, say, some fraud or he committed some mismanagement. But from a financial standpoint, there is no unpaid amount lying on a share that is his mistake. So he is not of any liability in that sense, in terms of only what management he has done. If he has done mismanagement, if he has siphoned off funds, if he has not made correct disclosures, you hold him accountable. But on the other side, the ownership is of the members or the shareholders, and they have no liability on how the company is run. If tomorrow a bad decision is taken, the shareholder is not liable. But if the company is undergoing losses, or if the company is shutting down, and if there are recovery agents coming, to the extent of unpaid amount on the owner's shares, on the members' shares, to that extent he is liable. So the concept of separation of ownership and management links to limited liability in this specific sense. Okay, so take 2 minutes to understand this and note this down, because this is generally not um, taught, or this is not generally explained, that there is another side of limited liability, which actually means liability of the owners and the members. They are liable to the extent of unpaid amount of their shares, and there the managers will not be liable, because they are not managing from a financial gain point of view. They are just taking care or running the day-to-day affairs of the company.
Ma'am, in company also the same thing will happen?
Yeah, in companies only I'm saying.
Okay.
Like, for example, if there are four partners who decided, okay, together, four of us, let us open a firm, and we are only running the firm, and we somehow had collected all the money, took some from our parents, took some from our friends, whatever earnings we had from our job so far, we pooled all that money and we started this firm. So the money is also ours, and we are only managing it, we are only running it. Then in that case, there is no separation of ownership and management. There is no need to discuss limited liability, because liability will be unlimited. You are managing, you are owning. If something goes wrong, who else will be catch? We will catch you. But when the ownership and the management is different, that doesn't mean that the owners are totally free and they can fly wherever. To the extent of unpaid amount of their shares, they will be held liable, but only to the extent of unpaid amount. That minute it becomes fully paid, then they're not liable. And the managers, from a financial point of view, you cannot hold them accountable. Only for the wrong decisions they take, of any mismanagement that they do, or any improper disclosures they have done, or any shortcomings that is specifically to be registered or filings to be made they have not done, then you can catch them, that they have made a default. But if the company is doing losses, then you will not say this particular director, make him pay. Okay? And whenever
Yes,
we say managers of a company, remember, we will always say directors and the KMPs. The directors, that is the board of directors, and the KMPs. Let me mention this in the chat box. Okay? Now, next, we are understanding the journey through the lifetime of a company, and our company is now at that incorporated stage, and we are trying to understand, once a company has been set up, once a company has gotten incorporated, what all activities can a company do? That is, after it has been set up and established, it has now legal validity, it has its own separate personality, it is ready to function and commence its business. What can a company do? Because what is it that the managers are managing? When we try and understand management of company, it's practically everything. As long as the company is alive, it's going to be managed. What is being managed? That means, what is a company going to do that requires a management? So let's think about this. Can you tell me, what all activities can a company do broadly? Or another easier way of maybe putting this would be, where is it mentioned as to what a company can do?
Selecting the employees.
Selecting the employees. No, I'm saying as in, okay, selecting the employees, but what activities does the company do? Like what function? Sales,
Production.
sales, yeah, sales, marketing, production, manufacturing, all of this. Where is it
Operational.
mentioned that a company can do this? Like if there are 100,000 companies doing 100,000 different types of businesses, where will you go and see that, where is it mentioned that this company will do this? MOA objects clause. I assume you are trying to say clause. Very nice. MOA objects clause. Perfect. So one is the MOA will mention what the company will do. Somebody also mentioned employees. So if we think from that perspective that a company is now going to hire employees, the company is now going to have a set of people who will manage it, they will issue shares. Where will all of this be mentioned? Where will it be mentioned? AOA, no? The articles will mention that the companies will have to have these many people who will manage it. The company can issue shares. It can also borrow money. That's two. Another place. Let me just tell you. Also, the Companies Act. So we have MOA and AOA, which will specify overall what the company is going to function as, what all it is going to do, what is the extent of each of those powers it will function, whose permission it needs. All of this will be covered in AOA and MOA. And then, of course, we saw last time that the Companies Act says that you can mention whatever you want in your MOA and AOA. These should be your clauses, but the Companies Act would prevail in case of any repugnancy, in case of any clash between MOA and AOA. The Companies Act would naturally prevail. So, Companies Act is the third source where it would be mentioned what all a company can do. And there is also one fourth source. This is, can you think of it? Can you think of something? Maybe if I say, if I categorize companies from the perspective of public functions like banking companies, insurance companies, telecommunication companies. So can you think where would it be mentioned what these companies can do? Prospectus. Can you elaborate on that? So this will be mentioned by sector specific regulators. That means the Banking Regulation Act will mention that a banking company will have to do this. The insurance regulator, the PFRDA, will mention an insurance company will do ABCDE. So the sector specific regulators also have the power and authority to specify these matters. And every banking company is first a company, just that it is a special type of company. It's a banking company. Every insurance company is also a company, but it's a special type of company. It's an insurance company, which means that their sector specific law and the Companies Act both will apply to them. So a Banking Regulation Act will specifically mention that the provisions mentioned in this Banking Regulation Act shall be in addition to that mentioned in Companies Act. So that company has to follow all the provisions mentioned in Companies Act also, and additionally follow all the stipulations and provisions mentioned in that sector specific law, which in this case is Banking Regulation Act. So these four sources, the MOA, the AOA, the Companies Act, and any sector specific provision or law will mention everything that a company can or may do. Clear? Is this clear to you? Okay. Now, why is it relevant, this portion I said about sector specific? Because as advocates, if you're all interested in corporate law specifically, you will do a lot of due diligence. Whichever position, whichever employment you take up, a portion of it will definitely include some amount of due diligence sometime or the other. This due diligence is a very wide term. Maybe we can speak more of it tomorrow when we discuss careers in corporate law. But a part of this due diligence is also ensuring the company client will come to you and say, I'm doing my filings, registrations, I'm doing all my disclosures, but I'm not sure whether there is any other authority to whom I need to pay any fees or show any details. For example, if there is a company, if there is say a banking company, and the Companies Act mentions that you have to file your annual returns, you have to file your annual report. When you appoint a new director, you should share your minutes with us, you should share the e-form filings with us. But what if the Banking Regulation Act also mentions that every time a banking company changes its directors, or every time a banking company sets up a new ATM or a new branch, then you have to inform the RBI also. So we as advocates, we are supposed to know whether any sector specific regulations apply on this particular company which has come to us as client. Because whenever we take up any transaction, the management of the company will submit all of its records and documents to you, and it is on us to identify that, okay, there seems to be this gap. They have not made any intimation to this particular sector specific regulator. They were supposed to do it. Okay, quickly inform the company to pay fines for the last 7 months because they have been defaulting in the last 7 months. So this kind of thinking or aptitude or perspective will only generate when you yourself are aware that not only company law applies to this company, multiple other laws also have a say or have stipulated certain provisions. Clear? Okay. So two things that comes out of MOA and AOA whenever we want to first start understanding how management of a company works is, firstly, as somebody correctly pointed out, the objects clause will mention what all functions the companies will do, the company is supposed to perform, like what business or what work the company is going to do, whether it is going to sell something, whether it's going to give some service, whether it's going to be a mix, is it going to be a huge like a multi service kind of a company, what is it going to be doing. So that functional aspect or that substance or subject matter aspect, or let's say the objects or purpose for which it is established, will be coming from the MOA. And everything else to facilitate the MOA, that is, if it wants to do a lot of sales, that means it has to first purchase a lot of raw materials. For purchase of raw materials, it might need a lot of money. It may not have all that money with it, so it might have to borrow or it might have to raise capital. So the facilitating side of it, all the procedure relating to what is mentioned in the objects clause will come in the AOA. I'll repeat this part. Whenever we're trying to discuss how a company is to be managed or what is to be managed in the company, we will look at two aspects. The first aspect is the day-to-day business of the company, the work that the company will do, the reason for what it is established, the purpose, whether it is sales, service, product, marketing, finance, whichever. The second part of it will be the facilitating of the first one. Like you need enough number of managers for it, you need enough number of creditors for it, you need enough number of say your permissions, licenses, all your necessary registrations, all your necessary money borrowing, capital raising, all of this that you're doing so that a company can run will come from your AOA. And that will mostly be procedural, how you are supposed to do XYZ, what is the procedure to ensure you get enough money, what is the procedure to raise this much finance, what is the procedure to pay the dividend, what is the procedure to determine what percentage should go as CSR. All of this will come from your articles, but what the company is doing will come from your MOA, and how it will do it will come from your articles. So the managers or the board of directors along with the KMP will constantly check whether they are fitting into whatever has been specified in the MOA and the AOA. Now, to the extent of what they are doing in the MOA comes as their day-to-day business, their daily affairs, their routine operations. This will be outside the purview of the shareholders. That means if suppose you own a company for, and you have appointed me as a director, I am trying to manage the company for you, there has to be some limit between us, right? We have to decide to what extent will you control me and to what extent will I handle the company and where will you step in. So when we say separation of ownership and management, that concept is so fluid. Where do you draw the line of separation? How do I know where your role ends, where my role starts, where my power ends and your authority starts? Where will we know that? The directors and the shareholders have this constant tussle, right? Each of them would want to have a say on how the company runs, but they have a specific role to play. Okay, so we will understand that is why I'm approaching the concept of management from this angle, that you understand it as the day-to-day activities or the functions or daily operations or routine business that the company is going to do, that will come under the purview of what the managers or what the directors decide. Where they should set up a new plant, who should be the people from whom they will take the supply of raw materials, or which bank do they want to hold an account with. These are basically routine operations essential for their functioning, but the directors will decide this. But other matters, such as if they are going to take a huge loan from the bank, how much money they're going to borrow from the bank, or how much money they're going to spend towards the purchase of raw materials, if this is a very significant amount, then the shareholders will step in and you will need to take their permission. But more of this a little later. Just for now, you understand this much, that the MOA will specify what business the company does. So AOA will specify all the facilitating aspects on relating to borrowing money, appointing people, auditors, inspection, all of that. Okay. Now, do you remember, if you have already studied a little bit of company law, that what was the doctrine or what is the doctrine of indoor management? Do you have some insight on that? By the way,
Yes,
any
ma'am.
questions so far? Any questions so far? Okay. So can any of you tell me what is the doctrine of indoor management? It protects the outsiders against the action of the company. Correct. And one more point regarding that. The exact same thing, but you can say the corollary of this. It protects the outsiders, which means Yeah, that's also true. But it means that it puts the onus on the internal management of the company. That means the doctrine of indoor management says that if the company enters into, say, for example, any contract with a third party, and that contract with that third party has specifies something in detail regarding how the company will maybe say purchase some raw materials from that third party, and later it turns out that the company had the directors or the internal management of the company had not themselves sat together, conducted any specific board meeting, and decided among themselves what they want to do in respect of this contract. So basically, so to say, their internal procedure was not correctly conformed to. They have not completed the internal procedures. Then this contract with the third party should not suffer. That means it will be assumed that when a third party is interacting with the company, then the company's internal management is done properly. If the company's internal management is not done properly, the third party cannot be made liable for any discrepancy in the internal management, because they could not have been in a position to know it. So the doctrine of indoor management helps to identify where the line of separation is for the directors and the KMPs. That means whatever internally they are supposed to complete in terms of procedure, you do your filings, you do your meetings, you do your these many days of notice, this much quorum, or the voting or resolution has to be passed, signed, all that procedure which has to be managed by the company within itself, the internal management has to be in place. And if it is not in place, then the outside third party cannot be held liable for any discrepancy in that contract or arrangement or whatever agreement they entered into. So the doctrine of indoor management protects third parties from liability and puts the onus on the company's internal management to have its procedures and practices properly in place. Quant rule. This came from that Quant case. You can just mention a note. This says the same thing as what the doctrine of indoor management, that the third parties will not be liable or cannot be caught for any discrepancy in the contract between company and third parties. Okay. Now, this is just the foundation for management, how the management happens, what is to be managed. Now, let us see who are the managers. Like we understood, the board of directors and the key managerial persons are the managers. So, you can note this. Chapter 11 and Chapter 12 of the Companies Act basically covers everything we need to know regarding management of the company from the board of directors point of view. So, this is Chapter 11 and Chapter 12. Chapter 11 is, do you have the Companies Act open, by the way? Please take 2 minutes to open the Act, because we will be doing provisions from the Act. So you will need it open next to you. Are any of you, from those who are in the session today, are any of you students who have not yet studied anything about company law? Can you just maybe raise your hand or mention in the chat box? Okay, many of you. Fine. Are you understanding how we're progressing in today's session? So the last session was introductory, so I was taking it a little slow. Are you able to follow today's session? Okay. So anybody, any questions so far? I understand that you have classes because it's a weekday till late. So we started the session late on your request. So anything we can't cover today, we'll complete that tomorrow. Okay. Malika, you have a question?
Yes, ma'am. Ma'am, I was going through the section of articles of association where a word entrenchment was mentioned. Can you please tell me what does it exactly means?
Yeah, what were you reading? Sorry.
The articles of association section related to that in the company law. Ma'am, I was having a confusion with the word that is entrenchment.
Infringement basically means a violation. When you infringe something, then you violate that particular provision, or entrenchment, where you are doing something you are not in the authority or power to do. You are going beyond what the law permits, or you're going beyond what the articles permit. So you infringed a provision, or you infringed a particular stipulation or prescription. Infringement means you have violated something, you've done some particular improper activity which is outside of the purview of your power, or outside of what the law specifies you are supposed to do, or you did not
Ma'am,
do something the law supposed. Yes.
Ma'am, I'm referring to entrenchment. Is it the same as infringement? I
Oh, you're
mentioned
saying
word.
entrenchment.
Yes, ma'am.
Oh, that would be contextual. Tell me where you saw it. Articles may contain, you're referring to section 5.
Ma'am,
Yes.
sorry, but ma'am, Rajnish Patel here.
Yes,
Uh,
sir.
should I explain the question raised by Monica?
Yeah, sure. I'm just checking whether she's referring to section 5 where it
Yeah,
says that
definitely. She is referring to section 5. Monica, please listen me. Are you hear me? Monica?
I think sir, Malika, can you hear what sir is saying? Yes, sir, you're audible to her.
Okay. So Malika, actually, you are talking about the entrenchment provision written in Articles of Association. Actually, any clause of the Articles of Association can be amended by passing special resolution, but any company may provide a provision that this particular clause should not be amended only by passing a special resolution, but it will be more than that. It means suppose 75% of voting is necessary to amend any provision of the articles, but sometime company may wrote in its article of association that it will be amended by passing 80% or 90% or even the 100% of the voting. So that type of provision is called entrenchment provision. Entrenchment provision means more than special resolution, means more than that necessitate more than 75% of voting. Is it clear to you, Malika?
Yes, sir.
Okay, thank you.
Thank you,
Okay,
sir.
okay, ma'am.
So in simple terms, what he's saying is that the company's law allows any company to mention in its articles that any particular transaction which generally requires a special resolution, the company can itself take it upon itself to mention that no, for this particular transaction, it will only be passed when there is more than special resolution. The companies that allows a company to specify such a clause in its own AOA, mentioning that beyond special resolution you would require that many votes to pass this particular transaction or agenda. So it gives the liberty to the company to have such a clause in its AOA. It can choose to have an entrenchment provision, or it can choose to not have it also. Can anyone except the directors be the authorized signatory of the company without board resolution to that effect? Authorized signatory would generally be a company secretary who would be a KMP, would not be a director. Okay. So can you open section 149, because that is where the appointment and qualification of directors start. So section 149, maybe those who have already learned company law can just hold on, as we have people who haven't done it. Let's give them a chance. Just read section 149 on your own once and identify the types of directors it mandates. And I will tell you how it has a bearing on what we do as advocates or corporate lawyers. So what I'm asking is, look at section 149 and tell me if you can identify 3 types or 3 categories of directors that the section mandates that the company should have.
Yes, the private, public, and one person company.
Those are 3 categories of companies, and the section specifies what is the minimum number of directors in these categories of companies.
3 directors in public, 2 directors in private, and the 1 director in one person company.
Yeah, very nice. But what I'm specifically asking for is types of directors. What you have answered is types of companies and the minimum directors they should have, minimum number of directors. I'm asking 3 types of directors itself that the section mentions. I will give you one, like, see, max directors. What is that? Like one, it mentions woman director. A category of director is woman director. It says that certain class or class of companies must have a woman director. That is one. Correct. Independent director. Very nice. And one more. It says that you also need a resident director, a director who has been in India for at least 182 days. Okay, so it just specifies. The reason why I am specifying this is, like we discussed in the last session also, that when we read any provision or when it is taught in class, when you go provision by provision, you will surely understand that provision. Like specifically in an isolated form, you will understand what the provision says, but how it translates to what we are going to do once we are employed or once we are interns, that is something we will not remember. So today, in today's workshop, I have set the tone for, whenever you understand management of the company, just remember the fundamental concept of separation of ownership and management. So every provision that we read, you remember it from that perspective, that is it within the purview of function of director? Is he supposed to make a decision about this on his own? Is he supposed to check with or take someone's permission before deciding it? Does the Companies Act say something about it? Or is it the liberty of the AOA to totally prescribe it? If you approach it from this perspective, then tomorrow when you are approached for any transaction, you will know where to check, how to answer that question. Was it the director's power or not? Will the Companies Act have any details on this or not? Is it the liberty of the AOA to specify this or not? Or should they have had some shareholders' permission for this or not? Is there any regulator, sector specific regulator, or any other registrar of companies type of regulator involved in this or not? So you will only know this when you read the each provision from this perspective. That is, how does it link with separation of ownership and management? And where does a director's power lie in this particular provision. Okay, so for that we need to first know categories. They've mentioned 3: woman director, resident director, and independent director. Now notice this about the Companies Act, that it is basically as a statute which facilitates or which is end-to-end deals with regulating or governing everything from the establishment to the ending of a company. So if we have a concept called separation of ownership and management, that means you all are the owners and you've appointed me as director, then the law has also specified how do you keep a check or how do you keep a supervision on what the director is doing. So a mechanism, one of the various mechanisms of doing this is that it specifies that the company will have an independent director. So an independent director is one of the categories of directors, and the concept of independent director is so widely explored, it is still so relevant in terms of what they do, because independent directors by their very nature of what they do are persons who are guardians or those who safeguard the interests of the owners, the shareholders. The independent directors, as you can see in this section 149, scroll down to subsection 6. Just give it a read once. Section 149, subsection 6. Just give it a read. Have you read it? So section 149 subsection 6 gives the criteria for independence. On what basis will you qualify a director and say that he is an independent director? For this, we require subsection 6, which says that he should not be a promoter, he's not related to the promoters or directors, he has no pecuniary relationship. So what is the purpose of having such a person as one of the managers? The purpose is that every decision that he sits for, he's part of all those meetings where matters are decided. He will be the person, or some many independent directors, so they will be the persons who will ensure that every decision is being taken with the purpose of the overall company's interest in mind, or with the owner's interest in mind. The shareholders' interest has to be safeguarded, and the company's overall scheme of operation should not be affected. It should progress towards what the company wants to be doing. So these independent directors don't have a pecuniary relationship with the profits the company is making. So every decision where money is involved, they are the checks and balances. They help supervise or they help keep an eye on those decisions, and they will give their opinions accordingly. So these independent directors are one of the many ways in which Companies Act 2013 helps the separation of ownership and management concept to function in a healthy manner. Otherwise, the balance between ownership and management has to be than the others, or if it starts tilting, then the company is not in good hands, or the owner's interest is not properly safeguarded. Okay, I will give you an example. So unfortunately, many things that is mentioned in the Companies Act is slightly far from how it practically works. So whenever we used to have certain training sessions, when I was part of the employment in the law firm, they would have some of these very elite people who would coach or who would give trainings to directors, and they would tell us how in certain meetings where a director who is personally interested in that particular agenda, or a director who has some pecuniary benefit from a particular decision, he's not supposed to attend that meeting. But in reality, it gets very difficult to ask these directors to excuse themselves and leave the meeting and sit out of it. So these independent directors are, even though a very strong and a very important mechanism to have in companies law, it's not as it's not as easy as it looks in terms of theory. In theory or in provision, it seems like it's doable and it's essential too. But it is very difficult for an independent director to tell one of, say, the promoter directors, one of the founders who is also a director, or one of the founder's wife or a relative who is also a director, and ask them to step out of a meeting because the agenda to be discussed is pecuniary in nature, or it is something that they are interested in. So in practicality, it is a little difficult to carry this out. And also, if you remember, for those of you who might have read it, there was this NCLT decision on the Tata Sons case where Cyrus Mistry was removed as chairman, and it was a huge hue and cry that happened, and NCLT decision came about. So there also they have mentioned how Mr. Ratan Tata is supposed to just be an advisor to the board, but what he actually does is much more than what the advisor should do. He sits in every meeting, he influences the rest of the board of directors, he tells them specifically that this is what the decision I want to come out of this particular board meeting, you make it happen. So the influence that these promoters have, or the influence that the founding fathers of the company, the founding promoters have on the board, is quite high. So even though Companies Act mentions these mechanisms to ensure that the purpose of the company prevails, or the owner's interest or the shareholder's interest is safeguarded, it is very difficult to make it happen in practicality unless the company is, ethically self-imposing ethical practices on it. Okay, so coming back, independent directors, what their nature is, we can understand from section 149, subsection 6. Next, duties of directors. One second. Yeah, also, every director has a director identification number. This is DIN. Let's do one activity. Okay, so it's 6:56. So at 7, we'll take a break. So let's do an activity. You remember last time how we were exploring that every time the Companies Act mentions this has to be filed, this has to be registered, where do we look to understand how it's to be done?
MSc website.
Where?
MCA website.
No, but where as per law, where do we look? The rules, correct. MCA website is also the correct answer. But I was looking for rules. So let's do one activity. The Companies Act mentions that each director must have a director identification number. So you just explore a few e-firm filings relating to this director's identification number. We have some time, so we'll be back by Sakshi, if you're on the meeting today. So shall we take a break till 7:10?
We can join us back because we can all join back at 7 p.m.
7:10?
Yes, ma'am.
Okay, let's do this activity once you're back.